Hey, it's Jeff with Remax here, and this is just a quick overview of the Pennsylvania Agreement of Sale. Now, keep in mind, I'm not an attorney, so I can't answer legal questions. I'm explaining this based on my experience of over a decade and hundreds of transactions. If you have any specific questions on this agreement, please let me know. I have about 3 to 4 different ways to explain each concept in this agreement of sale, and I only have the time to explain it one way, but would love to answer any specific questions you have. So let's start with here on page 1, and we put the buyer's names here, seller's names here. We put the property address in here along with the tax ID number to make sure we get the right property. Then we put the company information for the buyer's agent's information here along with license numbers for both. Same with the seller's agent and agent's company. We put in the date that we're making the agreement, the price, and we put the deposit in here. There are provisions for multiple deposits. Typically, it's a single deposit due within 5 days. Deposits do get made payable to the listing company unless it's a situation where there is not a listing company or other provisions need to be made. We put that information here. If you need seller's assist, it's not required, but if you need it, we put in a flat dollar amount here or a percentage amount. The maximum allowed is based on the loan type that you're using. We put the settlement date here, and this is an on or before date. Can be extended if both the seller and the buyer agree, as well as moved earlier. At settlement, all the taxes get prorated based on the settlement date and the tax period, and transfer taxes get split equally between the buyer and the seller unless otherwise agreed to. We put a date in here for acceptance to be on or before that date. In a perfect world, we always hit that date. It doesn't always work that way, but we navigate through that as it comes up. We put in the type of zoning right here and things that go along with the property. So there are a lot of things that are attached to the property, like wall-to-wall carpeting, window screens, storm windows, etc. Things that may not go with the property would be like refrigerators or washers and dryers, maybe some bar stools or a wood stove, things of that nature. Then things that are leased, a common example would be propane tanks, and things that are excluded. Let's say the refrigerator does not go with the property, or if there's a sentimental attachment to the chandelier in the dining room that the seller is going to take, they have to let us know that beforehand. If you're not getting a mortgage, you would waive the mortgage contingency. If you are getting a mortgage, we put the loan amount here, the term of years, and type of mortgage. Sometimes we use the loan to value percentage, but not always. We do put the mortgage lender information here along with interest rates, and we put the mortgage commitment date here. That date is when the lender says, hey, we have most of the things that we need for underwriting, and we're committing to doing this mortgage. The biggest thing that you have to remember with a mortgage is making your application within the first 7 days of the execution of the contract, the signing date. That way, all of the timelines that belong with the mortgage contingency fall in place, not quite automatically, but it makes it a lot easier. So 7 days, make that application. And here's the different timelines and information that goes along with that mortgage contingency. If you're using FHA or VA financing, the property does have to appraise for the purchase price, or you'll have to bring more money to settlement. If your financial status changes, say a loss of the job or some other type of financial emergency that does not allow you to move forward with the transaction, we need to know that right away so we can let the seller know. If it's public water or on-site water, we notate that here. Same with the sewer, public sewer, on-site sewer, you name it. Here's the different types of septic systems that are found throughout the state. There are other types as well, but these are the most common. Any historic preservation or land use restrictions for like preferential tax assessments. For example, clean and green. We have to know that stuff ahead of time. Moving on to the seller disclosure. The seller's disclosure sheet was developed to comply with seller disclosure law, and it gives an opportunity for the sellers to list everything that they know about the property. It also is designed to protect you as a buyer, where you can look at it and go, oh, here's everything they know about the property. any public or private assessments. For example, if a homeowners association or a municipality is bringing in streetlights, for example, and they do a special assessment based on the amount of people that it is affecting, we'd have to know that ahead of time as well. Highway occupancy permits is not something we typically deal with, but it can occur. Internet of Things. Homes are becoming more and more connected and tech savvy, as it were. A seller has the obligation to make sure that they are clearing out all of their accounts for things that are connected to their house at the time of settlement. You as a buyer also need to go in and make reasonable effort to make sure they don't have access to those things left in the house anymore. You have the ability to do some due diligence and do some inspections. If you waive those inspections, you're agreeing to the release in paragraph 28, which I'll cover later. You have the ability to do visual and functional inspections. So a home inspection, they're going to look at building materials. They're going to look at downspouts, swimming pools. They're going to run the systems in the home. If it's too cold, they may not be able to run the AC unit. As an example, everything that they can run, they definitely will. We have to have you initial to elect that or initial and waive the right to do that. Wood destroying insects, termites is a common one. Again, visual inspection. They're not ripping into things or opening walls. Deeds or restrictions or zoning. If you want to do a specific thing at that property, and if you can't do that, then you can't buy it. That's where you would use this contingency or due diligence. Water service, checking the quality and quantity of the well. This does not usually apply with public utilities. Radon. The state allows 4 picocuries per liter, and if it's above that, you can ask the seller to mitigate that. While not septic, they check the tanks, check the drain field, make sure it's functioning properly, and you can check to make sure you can get insurance on the property. If the property is occupied, most likely is possible, but you can still check and also check for make sure you don't need flood insurance. Property boundaries would be getting a surveyor to check out the boundaries, and you can also check for lead-based paint, and if there are other things that we need to do that are specific to that property, we can put that in here. You can also exempt existing conditions from that inspection as well. The inspection period is typically 10 days. We can adjust that to be shorter or longer as needed by the situation. By the end of that contingency period, you have to have the inspection done and you have to have a report to give to the seller, as well as what's called a buyer's reply to inspection. So on that reply to inspection, you have the ability to either accept the property as it is in its present condition, means you're satisfied with all the things that came up. You can negotiate, ask for certain things to be repaired, or ask for credit for certain repairs that need to be made. You can also terminate the transaction and retain your deposit. This just talks about the different timelines through negotiations of that, and if something were to come up with the septic system, there's different timelines for that as well. A title or a survey and the costs involved with that. So if the title company would require a survey, that would need to be paid for by the seller. Not very common, but it could happen. If you order the survey, obviously that's your cost to bear. Title work, if you're getting a mortgage, a title search will absolutely be required, as well as insurance, title insurance required by the lender. If you're not using a lender, you're paying cash, we still highly recommend that you get title search and title insurance. If there's any special notices or assessments or municipal requirements, we have to know that stuff ahead of time. So for example, some municipalities require a use and occupancy certificate. The seller is responsible for ordering that. They'll come out and do an inspection of the property, which is typical. And if there are things that need to be done for safety reasons, they'll give the seller a certain amount of time to make those corrections. Seller's not obligated to make those corrections. If they're not going to, they have to let us know that, and we negotiate how that gets done and who's responsible for those costs. If it's in a condominium or planned community like a homeowners association, you as a buyer have the right to review the homeowners association or condominium docs, all the rules, regulations, and so on. Seller has to request that and pay for a certificate of occupancy, or a resale certificate, and if the you have a certain amount of time to review those things. If you don't like what you see and you say, I can't abide by these rules, you can terminate the transaction. The assessed value of the property is what the taxes are based off of. The property does not automatically get reassessed just because you buy it. There are options for you to appeal that assessment if you feel it's too high. Some taxing authorities will also appeal that if they feel it's too low. Not very common, but it does happen. Seller has to maintain the property with some normal wear and tear allowed and maintain insurance on the property until the day of settlement. You can buy a third-party home warranty, and we will absolutely give you the opportunity to do that. Sometimes the seller includes it in the sale. That really depends on the situation. This agreement cannot be recorded like at the courthouse, and you cannot assign it to another buyer unless the seller agrees to that. All parties of the transaction are agreeing and subject to the law of Pennsylvania. And if the property is held by a foreign investor, we have to withhold taxes for that. That is not very common, and we will know that prior to making an offer. You can check with the Megan's Law to see if there are any sex offenders in the neighborhood. We absolutely recommend that you do that prior to making an offer so you know what you're getting into. We represent the property to you in its present condition and through the seller's disclosure and things like that. Terminating or default and getting your deposit back. A real estate company cannot release a deposit to a buyer or a seller until both parties have agreed on how that gets dispersed. If you need to terminate a contract, it has to be in writing. And on that termination, it states who gets the deposit and what portion of the deposit. If you're terminating within your contingency period as a buyer, you have the right to retain the deposit. If you're outside of those contingency periods, you're definitely putting your deposit in jeopardy. The seller is, when this box is checked, seller is limited to retaining the deposit as liquidated damages. If any disputes or claims would come out of this transaction or this agreement, we are agreeing to go to mediation prior to going to court. And here's the release that you're agreeing to if you waive contingencies. You're releasing the seller and all the brokers involved and the agents of any liabilities arising from the presence of termites or all of those things that you did not test for. This does not exempt the seller from disclosing things properly under the seller disclosure law, and you can still pursue them in a court if they violated the seller disclosure law. The real estate recovery fund is there if you have a judgment against a realtor and you can't collect on that judgment. The fund is there to assist you. If you need to communicate, the communications between the buyers and the sellers. When I communicate something from you, the buyer, to the listing agent, at that point, I'm not allowed to contact the seller. That's the listing agent's responsibility. So it stops when it's considered that I've communicated to the seller once I've communicated to the agent, and the same with the seller's agent communicating to me. There are some clauses that get put in on an agreement of sale, maybe sale and settlement of another property, or a short sale addendum, or an appraisal contingency, and those things would be listed here. Also, there are some other additional terms that we sometimes put into a contract depending on the situation. We will have given you a consumer notice, which is covered in another video, an estimated closing cost, which is also covered in another video, and a deposit money notice, which we talked about how the deposit gets made to the listing company, and also lead-based paint disclosure if the property was built before 1978. That's it. Any questions that you've got, please let me know. I'm happy to answer any questions that you've got on this transaction. Good luck.